Good afternoon, everyone, and a very warm welcome to this IUCN WCEL webinar titled The Road to Net Zero in Court, Just Transition and Corporate Climate Litigation. My name is Ivano Alogna, and I'm here with Dr. Kate McKenzie. Together, we co-chair the newly established Climate Litigation Cluster within the Climate Change Law Specialist Group of the IUCN Work Commission on Environmental Law. We are particularly pleased to welcome you to this event as it marks the first webinar of this climate litigation cluster. This cluster aims to support collaboration and knowledge exchange on cutting-edge development in climate litigation, with a special emphasis on comparative and interdisciplinary approaches. Today's topic, developed in close collaboration with the cluster, focuses on the intersection of corporate climate litigation and the concept of a just transition. As legal frameworks and climate strategies evolve, corporations are increasingly under scrutiny for their net zero claims, carbon offset practices, and broader impacts on justice and equity. We are honored to welcome three outstanding speakers who will each present for around 15-20 minutes. Kate and I will offer short reflection after each talk, and then we will open the floor for questions. So feel free to use the Q&A box throughout, and let's begin. So our first speaker is Dr. Arman Sarvarian, who is reader in public international law at the University of Surrey and an international legal practitioner. He has advised and represented states, companies, and NGOs before the International Court of Justice, the European courts, and in investor-state arbitration. Arman is currently a Humboldt Senior Research Fellow at the University of Kiel, working on the implementation of climate litigation law in Germany and the Nordic countries. And his talk is titled Green Investment and Corporate Climate Risk, the Rise of Carbon Credit Disputes. Arman, over to you.
Thank you very much, Ivano. My talk focuses upon not only the launch of the Article 6 mechanism, which I suppose one can say is a work in progress. So we had the decision, of course, in November, which completes, at least formally, the guidance that we shall receive from the CMA for the next 4 to 5 years. But, of course, there's a good deal of work, including at Bonn this month, ongoing, concerning the operationalization of Article 6. And I really want to push beyond the detail of how operationalization will work and how Article 6, whether under 6.2, the cooperative mechanism, or 6.4, the market mechanism, will function, towards some of the larger issues concerning carbon credit disputes, and in particular how, as I see it, we are likely to see in the medium term, meaning over the next 5 years, certain questions of integration into other areas and systems of international law. Beginning with an important definitional distinction between, on the one hand, emission trading allowances and, on the other, carbon credits. Emission trading allowances function within the scope of a compliance scheme or a cap-and-trade scheme. There are over 16 of these in existence in the world today, most famously the emission trading system of the European Union, which is linked to the emission trading system of the United Kingdom and of Switzerland. Within a cap-and-trade scheme, an emission allowance functions as a permit to emit for a regulated entity within a regulated sector. We had, of course, within EU ETS 1, something between 40 and 45% of the Union's total emissions regulated by the scheme, as opposed to the effort-sharing regulation. That is set to expand to something in the nature of 65% of total Union emissions with the launch of EU ETS 2. Now, within that logic of an emission trading scheme, over the course of time, regulated entities are permitted to emit fewer and fewer emissions within the course of typically a 5-year cycle. So within the course of a given cycle, they start with a regulated entity with the ability to emit more emissions, but in a downward curve over the course of time, they are subject to stricter and stricter targets. They can, of course, and this is the crucial point with respect to an emission trading allowance, there is the possibility of acquiring a permit to emit above their target, but over the course of time, that becomes increasingly expensive as fewer and fewer permits become available. Now, a carbon credit, on the other hand, and we do have a definition of this that is, I would say, semi-universal, that comes from the Kyoto Protocol guidance concerning the predecessor to the Article 6 mechanism, the CDM. And here for a carbon credit, we are speaking of a unit of CO2 equivalent, 1 ton of CO2 equivalent, representing a mitigation outcome. And a mitigation outcome I use within the technical sense provided under Article 6 now. Now, without getting bogged down into the detail of that, the crucial point from the outset to note is that an emission trading allowance and a carbon credit share an inverse or converse relationship. That is to say, a carbon credit is representing a mitigation outcome on the one hand, an emission allowance is a permit to emit within the course of a given period of time. Why is that important? We are seeing within current debate the possibility of exploring linking again between the new Article 6 mechanism and EU ETS 2 in particular. That's probably the most significant compliance market in the world, though it's not by any means the only one. And that in turn significantly affects the potential valuation of carbon credits to be produced under Article 6, the degree to which they might become freely tradable across other markets. And that, by extension, affects their attractiveness as an investment when in the context of the finance flows debate pursuant to Article 2 of the Paris Agreement. So in shorthand, we're looking at the potential expansion of the attractiveness of carbon credits. I'm focusing upon Article 6, that's by no means the only carbon market out there. And within that, the danger, as it of course occurred within the CDM and EU ETS 1, is of the credibility of the carbon credits, the mitigation outcomes that they represent being compromised in some form. And hence the very extended negotiations and the quite complex architecture that underpins what will now be the Article 6 mechanism. Now, linked to this question of linking, as it were, is the first decision that we had last year in Koch Industries versus Canada. Within the context of the investor-state dispute settlement system, the first arbitral award to consider a key threshold question, namely whether an emission trading allowance is an investment. The answer in that case was in the negative, but on quite narrow grounds. And where this links into the operationalization of Article 6 and its attractiveness as an investment and by extension to private capital and finance flows, is that if carbon credits or emission trading allowances, and they are two different things, are to be considered to be investments, at least some of the time, for the purposes of investor-state dispute settlement, that in turn significantly enhances their attractiveness to foreign capital. And that in turn, by extension, affects the ability of private capital to be directed in particular towards what is commonly called the developing world. So that's the first, if you like, extended question, as I see it, or consequential question of the operationalization of Article 6. There's the risk of so-called flooding of bad credits into an ETS. That's the danger with linking. But then on the other hand, there's the significant attractiveness that can be offered by enabling linking. Then we have the question of other disputes concerning carbon credits proper. And here we have the first dispute starting to emerge, really concerning the forestry sector in particular. Now, what's significant about forestry is that it's only included to a very limited extent within the current scope of Article 6, in particular 6.4. In terms of the recognized methodologies, we have artificial carbon capture and storage recognized as a methodology, seen, for example, the 2009 EU regulation on this. but we only have the enhancement of an existing natural carbon sink recognized as a methodology under Article 6. The conservation of an existing carbon sink is not recognized. For those familiar, that is the long-standing nature-based solutions debate within the context of Article 6 and the fear of reversals. In other words, of logging taking place contrary to, or other forms of compromising a natural carbon sink taking place contrary to a declared intention to the contrary. So in that sense, we don't have forestry conservation, properly speaking, included within the scope of current Article 6 methodologies, which means by implication that it's regulated or relegated to other schemes. And significantly, last year, we had the first declaration of CORSIA carbon credits within the framework of the Guyana-Norway Memorandum of Understanding. Now, I'm not qualified to speak as to the degree to which the architecture foreseen under that MOU was effective in terms of verification and compliance with respect to declared commitments on the part of Guyana for forestry conservation. But at least speaking as a lawyer, the architecture appeared to be quite robust. So in that sense, we had the first ever issuance of CORSIA carbon credits. That's not currently envisaged or possible under Article 6, but the possibility of linking between the CORSIA and Article 6 has not been ruled out, and indeed there are public discussions surrounding that. Now, there was a dispute concerning Guyana-Norway, that MOU, not to my knowledge anyway, but that's illustrative as the type of project that could lead to disputes in future. Some examples might be if a given foreign investor for the conservation of forestry with explicit aim of producing carbon credits, whether under VCMs, voluntary carbon markets, or under CORSIA or some other scheme, were to fail to meet those contractual objectives. That is to say, whether through negligence or other form of lack of due diligence, for example, the investor, the entity conserving the forestry pursuant to the agreement, failed to actually achieve that, say there is illegal logging for the sake of argument. We have had, publicly known, a dispute arise in the Canadian courts concerning the Rambaraya project in Indonesia. Now here, the matter is being pursued within the domestic courts of Canada, but theoretically, if an international investment agreement or instrument provide for jurisdiction, there's no particular reason why an ISDS, investor state dispute settlement, could not be pursued with respect to a carbon credit project. So forestry, I think, in the short term is the sector that obviously or immediately comes to mind with respect to potential carbon credit disputes. We have not had one hit the ISCS system as yet, but at least early indications in discussions with colleagues indicates that we're not far off. I think we're certainly at the advisory stage with respect to certain matters, and I suppose it is only a matter of time before one of these hits the grid. However, looking to the medium term or beyond this, one can see other types of projects, including those that have been pursued as pilot projects under Article 6.2 of the Paris Agreement, providing some fertile scope for dispute. An example might be an electrification project, one pursued between Switzerland and Thailand, for example, that led to the first issuance of Article 6.2, I use the term loosely, credits, and in particular concerning the current scope of verification of the pilot projects. But assuming that those will be formally recognized as ITMOs, as credits, that was the Bangkok electrification of buses project. So one could see within the transport sector, there seems to be an obvious one that comes to mind, the possibility of disputes arising concerning the treatment of a particular project by a host state. And the key point with respect to Article 6, at least to my mind, is that though it was not foreseen to be integrated formally into the investor state dispute settlement system, structurally, the way it has been set up is essentially a foreign investment vehicle, or provides a platform, let's say, for foreign investment vehicles. So long as that threshold question can be met, that these projects are investments, that will depend upon the definition of the particular investment instrument. But so long as that can be met, that threshold, there's no particular reason why they wouldn't be integrated into the ISDS system. That functions, as many famously describe it, as a form of political risk insurance, and that significantly enhances the attractiveness of Article 6 for foreign capital to be directed to such projects. My final point, in investor-state dispute settlement, companies and individuals as well can be considered to be respondents in limited circumstances. So principally within ISDS, they serve as claimants, so they appear as claimants, but in certain contexts, they can be considered to be respondents, most notably counterclaims, but also there is a certain risk assumed with respect to bringing these quite expensive disputes to the arbitral system, notably costs orders under the loser pays principle, paying for the respondent or host state's legal costs, which, to give a sense, can run easily into the multiple millions of US dollars. Within the context of carbon credit disputes, one could imagine certain situations in which counterclaims might be brought. For example, if there's an allegation of mis-selling or over-promising with respect to the delivery of certain mitigation outcomes or benefits pursuant to a given project, or whether damages have been incurred, or rather damages on the part of the host state can be significantly reduced through contributory fault. That is to say, for example, a failure to deliver certain mitigation outcomes. And in other contexts within investor-state disputes within the arbitral system that have engaged with climate law, we've started to see examples of this. For those familiar, see, for example, RWE versus the Netherlands, the failure on the part of the investor to deliver on artificial carbon capture and storage undertakings pursuant to their project. Thank you very much.
Thank you, Armin. Since we chose this topic based on the cluster membership's input, we want to make sure that we really connect these dots, and I'll try, and I'm just going to give some thoughts connecting what Armin just talked about to just transition. That's the whole idea here, is looking at corporate climate litigation and just transition. Some thoughts before we move on to our next speaker just on this particular topic are, if we think about just transition principles, really, it requires more than pure decarbonization, right? And it requires structural changes that prioritize justice, inclusion, equity at really at every stage. And one of the common critiques of the ISDS system, the investor-state dispute settlement system, is that it is not very transparent. And that for those folks who are impacted on the ground, the communities in which a lot of these projects take place, the workforce who are being shifted or moved to different sectors potentially often do not have a seat at a table. So it brings up questions of transparency, questions of equity and inclusion for me, and certainly also the further potential for litigation, specifically looking at issues of transparency and the actual reduction in emissions, the actual real mitigation potential of some of these projects, and of course the potential for overpromising and then greenwashing and overselling. So just some really interesting potential connections, even though the parties typically are the corporate entity and often a government, but it is the people, the community who are impacted by a lot of these projects that are implicated in many ways and don't necessarily have a voice in these types of disputes. So just something to keep in mind as we continue down the road of connecting corporate climate litigation and just transition. I'll pass over to Ivano again.
Thank you very much, Kate, and thank you very much also to Armin for this very insightful analysis. We go immediately to the second speaker, who is Mr. Raja Sengupta, an experienced corporate lawyer and sustainability strategist. Over the past 17 years, he has been advising multinational companies on complex compliance, governance, and ESG matters across India and beyond. Raja's expertise spans international trade law, corporate finance, data privacy, environmental governance, and policy advocacy. He also a Master of Laws in International Law and Arbitration. He is also a certified Lean Six Sigma Executive Black Belt, integrating problem solving and legal strategy. His presentation is titled Carbon Credits and Corporate Liability When Net Zero is Outsourced. Without further ado, Raja, please, the floor is yours.
Yeah, hi, thank you again. So, may I ask Roberto to share the PPT? Right. Thank you so much. So, yeah, so first slides. Yeah, hi, good afternoon, good morning, good evening, everyone. So, straight away to start with my presentations before killing the times to say about me, as already Ivano told me about me. So today we'll explore the legal, reputation, and governance risk of outsourcing net zero commitments through carbon credits. See, as you all know that as global carbon markets grow and corporate net zero pledges accelerate, over-reliance on offsets can expose companies to significant challenges. Let's dive into how firms can navigate this risk while aligning with science-based climate goals. So it is a brief definitions of the net zero, as you all know, that balancing emitted and greenhouse gases aligned with Paris Agreement 1.5 centigrade goal. And then there is a scale. And as you know that SBTi corporate net zero standard that requires 90 to 95% absolute emission reduction by 2050. Offsets permitted only for residual emissions and no offsets allowed for interim 5 to 10 years targets. So now the key questions, as you know, that though, as you already mentioned, that yet many corporate players like those from Chevron on EasyJet lean heavily on offsets, often using Vera rate plus credits that lack additionality. The key question is, are these pledges truly science-based or biodiversity aligned? Credibility starts with real reductions, not offset reliance. Next slide. Okay. So the anatomy of a carbon credit is that represents 1 ton CO2 carbon dioxide equivalent reduced or removed, certified by standards like Vera or gold standards. There are two types of carbon credits, that is avoidance credits and like rate plus projects in the Guyana government, you know that, and Hayes Corporation, $750 million agreement, which prevent deforestations and removal credits. Like Microsoft's deal, Climate Works for direct air capture. Okay, while avoidance credits support forest protection, removal credits often permanent CO2 removals. However, offsets are tools, not substitutes for decarbonizations. They must complement science-based reductions. So I'll just quickly complete all the slides because I have 10 slides. I think we do have 15 minutes for each participants. Next slide, please. Okay. So this is a common corporate activities when net zero is outsourced. Outsourcing net zero via carbon credits can lead to risk if not managed carefully. Over-reliance on offsets risk greenwashing and fiduciary neglect. Purchasing low-integrity credits like dubious forest projects invites fraud or reputational damage. Engaging unvetted third-party providers or failing to disclose offsets detail in ESG reports can trigger Security Exchange Commission, that is SEC, and CSRD non-compliance. Vague carbon neutral marketing may lead to regulatory action under consumer laws, and outsourcing to global south projects without community consent risk acquisitions of climate injustice. Tools like blockchain tracking, FIC protocols, and Scope 3, that is most important, Scope 3 accounting can mitigate this risk. Yeah, next slide, please. So these slides, like I have just given up, like it is a non-exhaustive, the types of corporate liability. Okay. So we have types of corporate applicable to net zero outsourcing and carbon credit misuse. That is, we know that public liability is there, reputation liability is there. Okay, tortious liability is there under tort law. Fiduciary liability is there. Criminal liability is there. Statutory liability is there. Contractual, human rights, and retrospect liability. So we'll not get into the more details on all the liabilities. Rather, we move into the next slide, please. Okay, so this slide is most important for this presentation. That is a legal exposure map when carbon credits offsets go wrong. Okay, so this slide is a completely crisp of the facts based on the judicial precedents. Okay, since 2021 till 2025. So legal risks are rising in 2025, as we know. These are all of the examples. Misleading carbon neutral claims, as seen in Deep versus Apple Inc. or Kedge's greenwashing cases, trigger consumer protection lawsuits. Inaccurate ESG disclosure, like in Swanson and Danimer Scientific, violates securities law. Failing to oversee offset integrity risk, director liability, as in Client Third versus Shell. Climate justice cases like the 2025 Para state lawsuit in Brazil highlights harm from unvetted projects. Jurisprudence demands substance over symbolic claims, making robust offset strategy critical. Next slide. So this is a brief legal and governance framework. It is an international framework which I tried to mention, but no doubt any legal and regulatory action should be aligned with the international and voluntary governance framework plus national legislations. So outsourcing net zero exposes firms to legal and governance risk, requiring alignment with high integrity standards like ICVCVM's core carbon principles and Article 6 mechanism. Article 6 of Paris Agreement, obviously. Scope 3 accountability and tools like net zero integrity scorecard are essential, especially under national laws in jurisdictions like India, Europe, Australia, etc., etc. Innovative solutions such as blockchain registries and AI-driven auditing can ensure transparency and protect privacy while meeting global standards. I'm not getting into the each and every details of these presentations because otherwise I need a 1 hour, more than 1 hour, maybe 2 hours time to cover up my presentations, what I'm trying to articulate. So let's move into the next slide, please. Okay. So these are as per my views. This should be the corporate best practice and the way forward. This is the non-exhaustive. I believe that there are many researchers and many experts are there on this platform who may add the value additions, okay, in terms of the corporate best practice, whatever I'm not covered here. And that is most we appreciate. So I will not get into the each and every part. Rather, I will just summarize what I'm just trying to cover up. To mitigate risk, companies must prioritize 90 to 95% internal decarbonization before offsetting. that is SBTI corporate net standard. Earlier slides I explained. Conduct due diligence on trade sources and ensure transparent ESG reporting. Avoid vague carbon neutral claims. Respect indigenous consent via FPIC and assign board level oversight for climate strategies. Emerging standards like ICVCM and technologies like blockchain or AI-driven geospatial tools enhance credibility. Jurisdictional partnership like Guyana government's model and community co-design projects signal integrity and equity. Next slide, please. So this is my last slides on the proposed carbon credit liability mitigation framework. I'm telling you this is something not like invented or something like exceptional framework which I'm suggesting. It is like a proposed based on my research and my experience on this field. Okay, what I gained throughout my professional career. But any idea to add on value addition or to improve on the framework, much appreciated. So these are steps I mentioned, starting from internal controls and continuous monitoring, stakeholder engagement and portfolio diversification, then contractual protections. That is most important, contractual protections. As we know, the landmark agreement, okay, Microsoft, okay, the way they have protected their third-party interest. Okay, next, credit quality assessment and due diligence, and then transparency and disclosure. So my framework emphasizes science-based aligned strategies, robust governance, and innovative tools to minimize liability. Use high-integrity credits, audit portfolios, and join initiatives like ILEAF coalition. AI and satellite imagery can verify project outcomes, while tying ESG KPIs to executive performance ensure accountability. By embedding climate integrity to governance, companies can avoid litigations and reputational harm. So I think it's the last slides. Next slide, please. So in conclusion, carbon credits are valuable but must complement, not replace, science-based decarbonization. Transparent, equitable, and well-governed strategies are essential to avoid legal and reputational pitfalls. Thank you. Thank you, everyone. Thank you for your attention. Over to Kate, please.
Thank you, Raja. It's such an interesting area. I'm fascinated by various layers, and I'm going to come back to transparency again on the just transition lens. And in here, I think a lot of the questions or the potential problems with transparency come from the fact that many of the disputes that we see in this particular world that Raja, you're talking about, are within regulatory agencies or the advertising agency, right? So it's disputes and potential issues, especially, you know, for greenwashing claims and those types of things that we may not see necessarily in the public sphere in a court like we typically would, because they are being handled in quasi-judicial settings that maybe are not as open to the public. So there's, again, some transparency issues here. You brought up a variety of interesting things that I won't take up too much of the time here. We can get into the discussion later on, but yeah, some comparative due diligence is an interesting perspective here, especially this is, you know, applies to some of what Armin was saying as well, but in particular here, if we're talking about outsourcing carbon credits, then where are we doing the due diligence? Which country's mechanism, which overarching mechanism are companies doing the appropriate due diligence, not just in the place where they're situated or the place of the project that they're outsourcing to or the credits that they're outsourcing, but is there additional due diligence that needs to be done on a comparative nature? I think also outsourcing in this particular context really can increase the potential for passing the buck on responsibility, which again has just transition and other types of implications. One of the things that I think is interesting in your metrics, your matrix that you have, that last image that you showed of the pyramid, One of the things that is not included there, and I think this is something we can have a part of discussion around this later on, but one of the pieces that is missing, I think often, especially from the corporate perspective, in really sort of assessing risk, is the risk of climate-related litigation that is not included in the risk matrix, right? Because that risk is always there, and it can increase or decrease depending on local, national, regional, international situations and laws. So that's just one additional piece that I think is important also to always keep in mind from a corporate perspective if you're going to go down the road of carbon credits, whether it's voluntary market or any other type of mechanism, to keep in mind in your continuous monitoring that the risk of climate litigation is something that ought to be included as a risk factor. I'll stop there, and we can move on to, I'll move past back to Ivano to introduce our last speaker.
Thank you. Thank you so
very
much, Kate.
Thank you also, Raja. It was really, really interesting. And also what makes particularly important is your emphasis on equity governance, the transparency, that part that Kate highlighted, and also the need to align offsetting practices with climate justice, scientific integrity. We are talking about this after during the Q&A. But now our final speaker is a great pleasure to have with us Professor Warren Levy, who teaches environmental law and policy across several departments at the University of Illinois, from law to medicine to environmental sciences, a long-time WCEL member and former partner in a global law firm. Warren brings really a unique interdisciplinary perspective, something that we always looking forward for this, linking also environmental harm and health impacts in climate litigation. So his presentation is titled Healthcare Providers' Roles in Climate Change Litigation. Warren, thank you very much for being with us. Over to you.
Well, thank you very much for having me. And I've learned so much from the preceding speakers. Let me focus in on an aspect of climate change litigation that is often not considered, and that is the role of medical evidence in litigation that deals with the just transition aspect of our seminar, as well as corporate climate liability. Sure, you need a wide variety of experts in climate litigation, and the cases come under so many different types of legal provisions and involving different types of evidence. The experts might be atmospheric scientists, ecological biologists, carbon accounting experts, even crop scientists or energy engineers. But what I'd like to kind of focus in on is the role of physicians and public health experts in helping bring these kinds of claims. They could help support standing of a particular plaintiff or groups of plaintiffs. They could help establish liability for corporations as well as government agencies. And also they can address remedies. So let me see if I can advance my slides. Yes. And so the objectives of my talk are to discuss these three areas. First is three examples of physicians' testimony in climate change litigation. Next, using medical records to show climate impacts and some of the concerns from a perspective of a litigator about the availability and robustness of medical records. And finally, thinking about engaging healthcare providers, organizations in filing appellate briefs in climate change litigation. So first example of physician's testimony comes from a U.S. case in the state of Montana. The trial court decision was in 23. It was affirmed by the state Supreme Court in 2024. Montana is a beautiful state. It is famous for Glacial National Park, but the glaciers have been shrinking. It's famous also for beautiful forests, but increase in wildfires. And also, Montana is known for the richness of the coal deposits and the extraction of fossil fuels that down the road releases millions of tons of carbon dioxide every year when it's burned for energy. So it's this confluence of factors that came together in this litigation. The specific legal basis for the litigation was a provision in the Montana Constitution from 1972 that establishes a right to a clean and healthful environment and an obligation on the legislature to provide adequate remedies to protect the environmental life support system. In contrast, Montana adopted a statute in 2023 that narrowed the scope of the environmental reviews for new projects, including vast new coal mines. The statute forbid agencies from considering the impacts of greenhouse gas emissions or climate change in their environmental reviews. Now, just to step back, Montana is, what we call a ruby red state, very Republican dominated. It is very accommodating for large businesses, including coal mines. And it does not have really a framework of climate change programs adopted by the state government. So it's not supporting a transition to clean energy, and it's not establishing targets for reducing the state's greenhouse gas emissions. And that's what was being presented to the trial court and the Supreme Court. Well, the plaintiffs here, 16 young people, supported by a national organization that has brought these youth-focused climate challenges in many states and on a national level. But the youths were supported by two physicians in their testimony. One, a local pediatrician, and the other one, a national expert in Washington, D.C., a psychiatrist. So the combination of physicians who can testify about local conditions and have credibility with a local judge and jury, together with a national expert. Now, the trial court made strong medical findings of fact, and these were unchallenged by the defense. The defense didn't put on any physicians at all, and the state Supreme Court upheld all of these medical findings of fact as being based on the evidence submitted by the physicians. So just to briefly go through this, children, whether they have pre-existing chronic conditions or illnesses or are otherwise healthy, are sensitive to climate change because their bodies and minds are developing. So when you think about the types of plaintiffs who could bring claims against government agencies or against corporations, children can bring health-related claims. They're suffering from heat waves, from wildfire smoke, air pollution, as well as the mental stresses, loss of ecosystems, familiar cultural practices, traditions, and their homes. And in particular, children have a higher risk of becoming ill or dying due to extreme heat. They also have increased stress and distress trauma that can impact their physical health as well as their psychological health. And they suffer from a range of respiratory impacts related to climate change, including some that are very widespread, asthma and allergies, but also some extreme ones, impaired physical and cognitive development. Just to wrap that up, the trial court held that the state constitution required the legislature to revise that statute. That is, that the environmental agencies had to take into account the contribution of the proposed projects within Montana to greenhouse gas emissions and climate change in order to fulfill the constitutional obligation to protect the health of youth in the state. And the state Supreme Court upheld this and found that these adverse health impacts from climate change were occurring and that the state had an obligation to address them through their environmental reviews. So, second example, very different type of vulnerable population. So in Montana, it was the young people who have greater sensitivity to heat and other climate-related conditions. Here in Louisiana, we're dealing with outdoor workers. And in particular, this case dealt with prisoners who were being sent to work in agricultural fields under extreme heat conditions. And some of these prisoners were on various medications that made them particularly sensitive to the adverse health impacts of heat. This is a case from 2024 brought on behalf of this, again, vulnerable population that doesn't have much of a voice in terms of the creation of statutes or government programs. This is prisoners. But more generally, it relates to people who have heat exposures, whether they are outdoor workers or working in warehouses or other types of facilities that are indoors but do not have air conditioning. And the relationship of the climate conditions, greater heat, extreme heat, longer heat waves, to the adverse health impacts and what that means for government agencies, like this Department of Prisons, but also other corporations that might be agricultural owners. They might be ones who do road construction projects during the summer, or the ones who have warehouses. So in this particular case, it was brought under the U.S. Constitution 8th Amendment, which prohibits inflicting cruel and unusual punishments. And the question was, whether the state prison system took adequate measures to protect prisoners from outdoor work under extreme heat, and whether that would comprise cruel and unusual punishment. So just as background, Louisiana, again, a very red state, very Republican dominated. But, in this case, it had increased heat-related fatalities, that their Department of Health has, pointed to. 2023 was a particularly bad year. It had more days with maximum temperature above 95 degrees Fahrenheit, and much more heat-related fatalities that year. So on behalf of the prisoners, the physician who testified, again, was a national figure coming out of New York University faculty. Her specialty was on thermoregulation, it's quite a narrow subspecialty of all of the areas of practice for physicians. And she was also certified as a correctional health professional. So her testimony, dealt with the connection between various medications and susceptibility to heat, and whether the standards that were being applied within the prison provided adequate protection to particularly vulnerable prisoners as to working under the hot conditions, and whether there were adequate rest periods, water intake, protective clothing, and such. And her conclusion was that the state did not recognize the vulnerability created by many medications, and that it didn't have adequate procedures. Now, unlike the case in Montana, here the defense did have, a physician, a chief medical officer of the Department of Corrections. He testified that all of the practices of the prison, were adequate to protect the health of the prisoners under the heat conditions. But the judge found that this testimony was far less persuasive than that of the New York-based doctor, and the opinion pointed to testimony or statements of the State Department of Public Health that heat exposure is intensifying as to the frequency, severity, and duration of extreme heat events due to climate change, and the actions of the State Department of Public Health to try to minimize the heat fatalities, particularly for outdoor workers. And that the court concluded that the practices of the Department of Corrections, the prison officers, was contrary to the advice of the State Department of Public Health on practices in light of the increased occurrence of heat-related conditions related to climate change. All right, so third example, case that's well known to many of the people on this webinar, Klima Seniorin. So we started off with the Montana plaintiffs, young people, and their particular vulnerability to climate-related conditions now and in the future. Here we're dealing with another vulnerable group, elderly women. So Switzerland has beautiful areas, a lot of snow-capped mountains and such, but it's also been suffering an increase in temperatures, and in particular during the summer of 2023, increase in deaths, with 95% of heat-related deaths brought by people over age of 75, and about 2/3 of those were women. So we've talked about two classes of vulnerable people because of the health impacts of climate change: young people and then outdoor workers. Here's a third, elderly women. And here there were three types of medical evidence: a doctor's statement, as to what she's seen, with patients, in terms of exacerbation of cardiovascular and pulmonary diseases. They also had the medical certificates submitted by three of the plaintiffs, as to the physical and mental health problems during heat waves. And then finally, the decision referred to some of the national and international authorities that connected up climate change with health impacts. And I'll particularly highlight the Lancet Countdown tracking the health impacts and climate change. And it's an annual international study published in the British medical journal Lancet. and it's very extensive, and the range of health impacts is very large. Not just heat, but infectious diseases and cardiovascular problems and renal problems and others. So, sorry, just to conclude on the Swiss decision, the European Court of Human Rights found that the Swiss government was not taking adequate measures to protect the health of these elderly women, that in violation of Article 8 of the Human Convention on Human Rights, that established, the obligation of states to take effective protections from the serious adverse effects of climate change on lives, health, well-being, and quality of life. So here it's a case brought against the national government, but to make our point about climate litigation, it also established the connection between potential plaintiffs, elderly women, and claims against corporations for emitting greenhouse gases and contributing to the adverse health impacts of climate change. So just briefly on two other topics. One is the use of medical records for litigation. So here, the World Health Organization from 2021 was asking nurses and doctors to collect and record evidence in their medical files that could be used by expert testimony in environmental litigation. But there's a real problem. There's an underreporting of heat-related illnesses and deaths, or other implications of climate change for health. So really, it's a message to get out to healthcare providers, hospitals, and other organizations to try to develop proper coding for climate-related illnesses in order to provide for better expert testimony in environmental litigation. And one final thought is that healthcare providers can be helpful in appellate litigation as well. So we've talked about testimony from various types of physicians, but the many medical societies, have issued statements urging for greater action on climate change mitigation and adaptation, and they followed up their positions with filings, with appellate courts on litigation relating to energy production, and transportation, and other issues. And in these briefs, they point to medical studies showing the harms from climate change. So again, it can contribute, along with experts from atmospheric scientists, biologists, and many other fields, to establishing the standing of particular plaintiffs, the responsibility of governments, agencies, and of corporations, and the need for remedies. All right, I'll stop there. Thank you very much.
Thank you, Warren. I'll give just a couple of comments specifically on Warren's talk as well from a just transition perspective. And then I'll pass over to Ivano to kind of give a perspective from a corporate climate litigation lens, and then we can open up for questions and discussion to anyone who has them. Please do use the Q&A function for your questions. We have a couple of questions in there that we can get to, but please do continue to add in your questions so we can have a nice discussion later on. So just some comments on what you had to say, Warren, from a just transition perspective. I think it's a really interesting topic area of looking at the distinction between medical evidence in climate litigation versus climate science as evidence in climate litigation. And I think that where we are with climate science and the other sort of natural sciences as evidence in climate litigation is still a little farther removed from medical evidence, right? I think there's a sense that medical evidence is so much more direct and so much more clear in many ways that it really can be useful to have a medical expert in litigation to help overcome hurdles like standing and some of the merits and facts of the case. I think there's also the potential, if you think about what the other two speakers talked about, right? How does medical evidence fit into some of those type of disputes that we're talking about? I think there's an opportunity for healthcare and the medical profession in general to take on a little bit of a new and a sort of expanded role in particularly in cases of vulnerable communities or communities that are impacted by climate-related projects, right? Is there a consequence on a vulnerable community, a health consequence of a vulnerable community of something happening, whether it's a well-meaning project, right? Then we get into, different type of disputes or not. I also think that the health industry itself is at the front lines of climate change in a lot of ways, not just as a source of evidence and a source of information, but as a system that is struggling and being impacted by climate change as well. And that, of course, then relates to any sort of legal dispute that might be in existence as well. For one thing, health systems are seeing new and different types of diseases because of a shift in weather patterns and climate. In the UK, I know the health system is starting to see a lot more tropical diseases that we're not used to seeing in this country, just because they're becoming more common as our climate shifts here. The stress on the system to be able to deliver healthcare is being impacted by just the physical nature of climate change, and then also being impacted by policy decisions that are being made. And particularly when we talk about vulnerable populations, you already mentioned them a couple of times in your talk, Warren. What's missing, I think, from some of the discussion is when you have an existing vulnerable population for whom health conditions are exacerbated by climate change, then you also have a health system that is being affected by climate change. The ability to continue to provide the now increased need for care for already vulnerable, high use populations of the healthcare system goes down. Really, it's really problematic. Right. So I think it's just it's a really fascinating field to focus on medical evidence in not just individual cases, but also the potential for larger corporate cases. I think your mentioning of the Louisiana case was really interesting, the prisoner case. That it made me think of there's a really sort of standard practice in many states across the United States, and I'm sure this is a practice in other countries as well, to use prisoners as supplementing the firefighters to fight wildfires. California uses prison population. And of course, there are human rights issues there with, using free labor and all that type of thing. But there's also that health impact of sending folks who are vulnerable because of their situation, not necessarily their health, their existing health situation, but just the context, dangerous places that have been exacerbated by climate change. I think there's some really interesting ongoing questions there. I will stop on my comment. I could continue talking about this particular topic with you, Warren, forever, but I'll stop there so we can open up for some discussion. I want to just connect all the three things before I pass it on to Ivano to give his thoughts. One final thing, and I'll jump in again after Ivano's had a chance to give his thoughts. But the big questions for me, overarching questions when I look at corporate climate litigation and the just transition, and all three of the topics that we've had that are a little bit disparate, but they are all connected. The big questions that I tend to ask in these types of contexts are who benefits and who bears the cost, right? To really have an understanding of who are the players and who's the benefits and the costs of that. Are solutions equitable and transparent? I think that's a really big question, particularly when we're talking about investor disputes and some other corporate related litigation or disputes, particularly when they're in sort of the quasi-judicial settings, right? So really, are they equitable and transparent? And then the third really important sort of overarching question is how much responsibilities should corporations have for both past harms and also future solutions? How much responsibility should we be putting on corporations, private entities who are engaging with the various mechanisms and markets on the future solutions that they're creating and what they ought to be presenting? I'll stop with those questions and let Ivano give his thoughts on context of presentation while we give folks some more time to gather questions, and then we can start into a question and answer session.
Thank you very much, Kate. No, thank you very much for those excellent reflections. Also connecting each of these interventions to this broader theme of justice and equity during the climate crisis, but also probably in the climate transition that we are trying to experience in this moment. So thank you so much also, Warren. Your presentation makes really a compelling case for why the health sector must play a central, and should play a central role in climate litigation, not only to document harm, I would say, but also to push for stronger preventive and adaptive action. So what ties all three presentations together is the increasing integration of science, justice, and also this corporate accountability from climate finance, emission trading, offset governance, to public health impacts. So at the heart of all of this lies a little bit a core question, you know, to going to add another one to what already asked Kate, of corporate climate responsibility. What duties do companies owe to people and the planet in the name of net zero? And how can the law really serve as both a constraint and a catalyst for their transformation? This is a little bit what we are trying to understand. And building on that, I'd like to highlight how today's presentation really contribute to a deeper understanding of the evolving landscape of corporate climate litigation, because as Kate said, they were very disparate and very different kind of presentation. What we've seen is how different areas of law, we talked about international investment law, consumer protection, human rights, and even, as I said, healthcare regulation, all of these are increasingly intersecting with climate objectives and holding corporations accountable not only for what they emit, but also for how they promise to decarbonize, what tools they rely on, such as carbon credits, what impact they have on communities and ecosystem. And so this multifaceted scrutiny, be through litigation, carbon market instruments, the integrity of net zero claims, all the health consequences of corporate and state inaction, confirms really a central insights, even from the research that I lead at BIICL on the global toolbox on corporate climate litigation. The corporate climate accountability is no longer siloed. It crossed across legal system, doctrines, stakeholders' expectations also, and requires comparative interdisciplinary approaches, as I said at the beginning, to address both the legal responsibility and the social legitimacy, because this is embedded. At this moment at BIICL, we are going from the first 17 countries to adding 10 new countries analysis, where we try to really span our research on corporate climate litigation through all the different areas and fields of law, and trying this year especially to work a little bit more on the disciplinary aspect. So I also think today's intervention underscore that the courtroom is not isolated from the wider political and ethical debates about climate governance. We've seen in the Clima Signorina, in the Montana, all the cases that we touch upon, the rise of carbon credit litigation as based legal strategy. And as I said, these investor disputes point to a need for both legal innovation and also, I would say, judicial courage. And with that in mind, We are very much looking forward to your question and reflection. I see that there are already some questions. So as Kate said, please feel free to type your question in the chat, and we try to get as many as possible. So thank you very much. Kate, over to you.
Thank you. And it looks like we may have lost Raja. So I think this first question, these are some questions that came from the that are already in the Q&A. And I think the first one, I think Ivano, maybe it might make sense for you to actually take this, but anyone feel free to answer. The question is, what are the available legal remedies for communities and or private companies should they not be happy with the project that is being implemented in the subnational level covering their area? Any additional thoughts aside from just sort of normal, just, you know, the legal routes that we generally have? Are you aware of any existing sort of legal remedies for communities specifically focused on these projects? Ah, there's Raja. He's back.
Raja is there. Okay.
I'm so sorry.
Ivano, any thoughts on that?
Yes, please. Priority to Raja, of course.
Raja, yes. Do you have a response?
Yeah, what is the question? Can you please repeat?
Sorry, we had lost you and you came back. So the first question from the audience was just a question on what are the available legal remedies for communities and or private companies should they not be happy with the way a project is being implemented in their area?
Okay. So the two things, one is the legal remedies and one is the better to say that what we can take an initiative to not to go to legal, right? So legal remedies as such that still you all know that the climate change law is evolving, right? So better we should focus on the company's internal control and the due diligence for the particular project which relates to climate change. So coming back to internal control, so it is very difficult to conclude in this webinar, but I'll just quickly give you some bullet points. So for the internal control, like conduct through due diligence on offset providers, ensuring verification by standards like BERA standard, gold standard, or CDM. So these all are not regulated. These are as per the company's best practice and based on the company's process and policies. Scrutinize offset projects for permanence, additionality, leakage, and risk of double counting. So these all internal control is based on the various climate change litigations and the judicial precedents in place. Okay, the lawyers and the compliance expert analyze those judgments and came to the conclusion that these are the, as of now, considering the present situation, these are the pointers which the corporations can consider in the internal control process so that they can avoid the climate change litigations on the risk in future. Okay, so next point is a maintain detailed records of carbon credit transactions, including project types, volume, dates of issuance and retirements, and verification documents. Next one, align reporting and disclosures. See, reporting and disclosure now is mandatory, not only for the international perspective, even for the national legislation perspective. Mostly 90% countries already implemented their national law aligning with the international conventions and the guidelines and standards. So maintain detailed records is most important, okay, as per those guidelines and the national law requirements, and the verification documents, obviously. Align reporting and disclosures while frameworks like that, GHG protocols like green gas protocol, then ISSB, IFRS to ensure consistency, transparency. The accounting guys, they know that they have to report as the IFRS standard, right? Based on the, obviously, you see, whatever I'm telling, this should be aligned as per the national legislation. Okay, so whatever I am telling that this should be the best practice for the global organizations, but always the person in concern should check the national legislation in place, because ultimately when the dispute will arise, if the company don't have the global like multinationals and having a different presence in different countries, then the national law should be applicable. So everybody is like adopting these practices should be considered the national legislations, including the best practice, whatever I am mentioning, or everything available based on the compliance and legal expert. Like next, the clear distinguish between offsets applied to scope 1, scope 2, and scope 3 emissions. Importantly, scope 3 emissions. Then regularly audit offset usage to confirm that claim reduction match actual retired credits. That is most important. Then establish cross-functional oversight involving sustainability, legal, finance, and audit teams. Then implement internal review processes before public ESG disclosure, marketing, investor statements, referencing carbon neutrality or net zero goals. Like these are the like a basic points what I am telling. That there could be other many points. So this like internal control system of the company, either that is a company don't have the global presence or the multinational, or maybe the company do have the national presence, or they have the multinational presence. Everybody should have a robust internal control in place, especially that is most important if the company is a multinational company. Over to
just to interject very briefly, Raj, I fully agree with you. And I think that that was one of, the idea of making sure that that due diligence is done in every jurisdiction that is implicated, right? It's the jurisdiction where the project is happening, the jurisdiction where the company sits, the jurisdiction where the money is, right? So all of those jurisdictions, that due diligence has to really, really be done. I'm going to we have a couple more questions from the audience. So I'm going to just quickly, apologies for cutting you off, Raja, but I wanted to get Ivano's perspective. If you had anything to include into what Raja was saying. That was a really excellent and very detailed answer. Thank you, Raja.
welcome.
Ivano, did you have anything to add?
No, thank you very much. I think that it was quite rich, as the question is quite also complex, because communities and private entities that are dissatisfied with this jurisdictional climate project in their legal system, like this one, this Forest Carbon Partnership Facility, I think this is quite, it's open up very different, very different issues. So in a way, there are several legal remedies. They may be available depending on what is the national legal system where we are talking about, and also depending on the specific governance structure of the project. So it's very, we have the judicial review, of course. We have, as we said, the grievance redress mechanism. Human rights is another possibility, as you said also. It's also a question also related to the indigenous people that might be affected. So could be something related to customary rights. So this is quite also interesting. I discussed this last week in Paris with some colleagues on another project. So I think this is quite interesting. And of course, there is as a big chunk of everything that relates to this kind of cases. There is a big chunk of the civil law remedies, so could be tort claims. So yeah, the toolbox as usual is quite, but on the other side, there are also the fact that access to remedy remains a challenge, especially in this jurisdiction with weak enforcement. This is really the moment that we have to start working a little bit more on the enforcement part, and also those countries where there are some problems related to, I would say, limited judicial independence, if I can say so. So I would say that. Strengthening in a way the legal frameworks, participatory governance is key in ensuring that these climate initiatives are not just effective, but also, as we are talking about this today, equitable, rights-based. So I think just this. I mean, the rest, it was excellent. Thank you very much, Raja.
Yeah, thank you so much. Just Ivano and Kate, just to add, if the audience have any kind of doubt, and just quick like a guideline. If you see, there are a lot of confusion, the national legislations, international guidance, court judgments, there are many things. So just keeping aside everything, if anyone want to start from some scratch, okay, they should refer the Microsoft 2030 Net Zero Strategy Guideline that is available on the public domain. Okay, the detailed guideline that Microsoft published. Okay, I will not tell that is 100% compliant. That is not good to comment on others' document, but that is can be the benchmark document to start. Thank you so much.
It's a good place to start. Yeah, excellent. Thank you for that resource. We have a question for Warren specifically. Do you think the existing legal communication and drafting of legislation, terminology, and language are sufficient to address the climate-induced health-related cause of actions in the court of law?
Well, great question. And the simple answer is no, that it's not sufficient. We need clearer obligations on corporations. Now the medical evidence is so clear about connections between climate-related conditions and health impacts. I'll give you one example. We talked about the Louisiana case and outdoor workers being exposed to heat. Well, there are several, a few states in the US, that have adopted legislation to protect outdoor workers under extreme heat conditions, particularly agricultural workers. But such legislation is not widespread, and some states that have a lot of vulnerable people who are getting ill and dying because they're working in hot conditions, and the heat waves are becoming more intense. Some states, like Texas and Florida, have actually prohibited any such protection for outdoor workers to be adopted at the county or municipal law level. So we need stronger legal frameworks. Actions can be brought in terms of public nuisance and negligence and such, but in light of the clear connections between the climate conditions and health, these really should be addressed very clearly with additional statutes.
Thank you, Warren. We have one final question in the chat and a few more minutes. So this is a question I think that all of you can speak to this, but it may be more interesting, most interesting also for Arman to give his perspective on. Do you think the different perspectives on carbon credit asset class from common law and civil law countries will complicate the implementation of Article 6? And I would like to add not just common law and civil law, but then we also have an interesting wrinkle of Islamic law, under which Islamic finance law really has a hard time with these things. And it's an ongoing discussion how carbon credits could even function in Islamic law. So that's just an additional wrinkle. But the common law, civil law perspectives, how much is that going to complicate things, Arman?
I think there's a twofold answer to that. On the one hand, there's the operationalization of Article 6, is really just getting it to function in a variety of given jurisdictions. And then on the other, there's the consequential status of Article 6 credits. And I focused on the investor state dispute settlement system, the definition of an investment. One could widen that to other contexts as well, but just taking that as an example. In terms of operationalization, yes, there might be certain complexities. The simple, and perhaps that is the only answer that can be given, the simple answer is that it will be for each respective state party to address them. If and insofar as that state party participate in Article 6 at all, which is not obliged to, of course, to do so, whether 6.2 or 6.4. So there will clearly be, and this will affect the attractiveness of Article 6 to private capital, of course. And one should emphasize, I think, that at least in the early days, so far in the 6.2 pilot projects, we've really seen Japan and Switzerland go in big in terms of 6.2 private pilot projects. So insofar as that has been concerned, we have yet to see real problems in terms of the projects that we have. But that's only 2 states. So that's not to say that those won't come in future. But one thing that's been remarkable has been more so in the Swiss case, less so with Japan, but the degree to which even up to 6.2, which was designed to be almost a mirror image of 6.4 in terms of it being intergovernmental in form. And I think to a significant degree, the working assumption was that it would be public money or public vehicles going into 6.2. Nonetheless, it's been quite significantly private companies have actually been doing the projects under 6.2, albeit under an intergovernmental MOU. So different in form largely, but in terms of who's actually doing the projects, not so different from what one might expect to see under 6.4. So in that sense, that's a way of getting around to then this question of status, at least insofar as the state party is concerned. If states are going to be, by and large, relying upon the private sector to actually do these projects, such as the Bangkok project I mentioned, electrification of buses, which in that case it was essentially private companies doing it, then they will have to clarify as a matter of their internal law what will be the status of these carbon credits that are produced. The ITMOs in that particular case were transferred ultimately to the federal government of Switzerland, but by a very interesting and somewhat ingenious framework, whereby, in the interest of time, I shan't elaborate, but the shorthand is that effectively fossil fuel importers to Switzerland, pursuant to Swiss law, had to purchase these ITMOs and transfer them for free to the federal government of Switzerland. So it's just interesting when one sees the early architecture, how this could arise. And then the other, the consequential issue, focusing upon investment law, the status of an investment, yes, is the short answer to that. The long answer, I would say, is see the case I mentioned, Koch Industries versus Canada, in which this was foursquare. That concerned emission trading allowances, so it's not the same as a carbon credit, as I mentioned, but nonetheless very interesting to see how most of the award boiled down essentially to what does property mean in the law of Ontario. That essentially was the bulk of that decision. To my mind, the more interesting part of the decision was the one on which the tribunal spent less time, but nonetheless, it's striking to see. Yes, I mean, when one looks at then, it's a very fraught question. What is an investment? There's a real variety of definitions with which one has to contend. But if one is engaging with national law, in particular to a closed list system like that of NAFTA, in which you have property referred to, then the question is, what is property? Then inevitably one goes into then, I think inevitably, the local law of the particular host state, as indeed was the case in that particular arbitration. And that's the first one we have publicly known on either an emission allowance or a carbon credit and their status as an investment.
Thank you for that, Arman. I will pass over to Ivano to close us out.
Thank you very much, Arman. Thank you, everyone. Thank you all for joining us for this, as you've seen, very rich and timely conversation. So on behalf of the IUCN WCEL Climate Litigation Cluster, we are really, truly grateful to our 3 speakers, Arman, Raja, and Warren, for their insightful and engaging presentation, and to all of you for your participation, thoughtful questions. So before we close, I would like just to take a moment to sincerely thank our colleagues in the Climate Change Law Specialist Group, whose support and collaboration have made this event possible. In particular, our thanks go to the co-chairs, Francesco Sindico and Fabiano de Andrade Correira, for their continued leadership and vision. We also warmly thank Roberto Conley and Marina Dutra Tirindadi for this essential role in coordinating and guiding the work of the group. And of course, I would like personally to thank Kate, my co-lead, for the always great pleasure working with you. And today's discussion reflects really exactly the kind of cross-cutting comparative dialogue that the specialist group is fostering. And we are proud to contribute to that collective effort through the work of the climate litigation cluster. And please do continue to follow us and try to connect with us, because we would like to expand this group and to make sure that it's going to be even richer. So this webinar marks the first in a series that we plan to hold over the coming months. So we look forward to staying connected and deepening this conversation. Thank you again, everyone. And of course, on behalf of Kate, we wish you all a great rest of your day. Thank you very much, and bye-bye.
Thank you, everyone.